Hello, good afternoon, everyone. Welcome to the fifth episode on the lecture on the Corporation Code. This afternoon, I'm going to discuss the Title 5 bylaws. This is a very short topic under the Corporation Code. We will just discuss again the more important details so we can save on time. Now, bylaws class, when you say bylaws, these are the internal rules among the stockholders, no, the internal rules, and it cannot affect or prejudice the rights of third persons who deal with the corporation unless they have actual knowledge of the provision of the bylaws. Now, a bylaw is or bylaws are regulations, ordinances, rules, or laws adopted by an association or corporation, no, for its internal governance. When you say internal governance, these set of rules apply only to the corporation, the stockholders, and its board of directors. The internal governance can pertain to some rules, no, pertain to the routine matters, for example, on how to call a meeting and the likes. Now, what are the requisites of a valid corporation? It must be approved by affirmative vote of the stockholders representing the majority of the outstanding capital stock or majority of the members if filed prior to incorporation, approved and signed by all incorporators. Now, class, take note that this is the only instance where majority vote is required by the corporation code. Again, in order to approve the bylaws, you need a vote of majority of the board of directors and majority vote of the stockholders. Majority. Again, I have to emphasize, this is the only instance in the corporation code where the required vote is majority. Now, if the bylaws is filed prior to incorporation, then it must be approved and signed by all incorporators. Okay? Now, again, class, because I have discussed this in the fourth video, that what in the third video rather, that a bylaws is not a requirement for purposes of incorporation. In fact, the bylaws can be filed within 30 days after after the issuance by the SEC of the certificate of incorporation. Okay. Now, the bylaws must be kept in the principal office of the corporation, subject to inspection of the stockholders or members during office hours. It must be consistent with the corporation code and other pertinent laws and regulations. Again, it must be consistent with the law and also with the articles of incorporation. It must not be unreasonable. It must not be arbitrary or oppressive. Most important requisite of a valid bylaws is that it must not disturb vested rights. It must not impair contracts. It must not impair property rights of the stockholders or members or create obligations unknown to law. Okay. Actually, class, the last requisite is the catch-all phrase. It may not violate the existing rights of the stockholders. That is the essence of the sixth requisite. Now, class, no, the bylaws can only be binding upon issuance by the Securities and Exchange Commission of a certification that it is not inconsistent with the corporation code. Without certification issued by the SEC that the bylaws are not inconsistent with the corporation code, then it has no binding effect insofar as the corporation stockholders or the board of directors are concerned. Now, the bylaws cannot bind stockholders or the corporation pending approval by the SEC. Okay. So as to the corporation and its components, a bylaws is binding only upon the corporation, but also upon its stockholders, members, and those having direction, management, and control of its affairs. On the other hand, the bylaws, take note class, is not binding unless there is is not binding as to third persons unless that third person or those third persons have actual knowledge of the provision of the bylaws. Now, the uh, um, the corporation and its stockholders, no, the bylaws have binding effect by or among them. Although third persons, again, I have to emphasize this, are not bound to investigate the content because they are not bound to know the provisions of the bylaws of the corporation that they are dealing with. Okay? And that there is no presumption in law that they are actually notified with the provisions of the bylaws. In other words, class, since the bylaws are internal in nature, then it does not bind persons who are not part of the corporation. These are the contents of the bylaws under Section 47. No, the time, place, manner of calling and conducting regular or special meetings of the directors or trustees, or the regular special meetings of the stockholders or its members. The required quorum also, class, because as you know, the required quorum is 1/2 plus 1 or the majority. However, class, the bylaws may specify for a higher voting requirement or a higher quorum, or a higher number, a higher required number of persons before a particular transaction can be had by the corporation. The form of proxies of stockholders and the manner of voting them, etc., etc., the qualifications of a director, okay, the holding of annual election, the manner of election, the penalties for violation of the bylaws, and in case of a stock corporation, the manner of issuing stock certificates, and such other matters as may be necessary for the proper or convenient transaction of its corporate business and affairs. If I want you to remember a particular concept under bylaws or Title 5, that is the manner of amending the bylaws. The bylaws, no, majority of the members of the board and majority vote of the owners of or the stockholders or members in a meeting duly called for the purpose. No, it can be amended, no, by majority vote of the board and majority vote of the stockholders. Now, class, since the bylaws is internal in nature, or it refers more on the day-to-day activity on how the board of directors will run, no, the will govern or manage the corporation. No, internal kasi yan eh, no? Kailan magmi-meeting, paano ipapadala yung meeting, pwede ba yung teleconferencing or video conferencing, how many days are required prior to the sending of the notice, etc., etc. So these are internal matters of the board. Now, since the bylaws are internal matters of the board, then no, the stockholders can delegate to the board itself the power to amend or repeal these internal rules by a vote of the stockholders representing at least 2/3 of the authorized capital stock or of the members. Now again, since the bylaws are internal to the board of directors, it governs the specific rules or formalities which is required of the board, then the stockholders may not necessarily be interested in engaging themselves into this nitty-gritty on the conduct of the meetings of the board, which is why by a vote of at least 2/3, no, of the stockholders or the members, they can delegate to the board what? The power to amend the bylaws, the power to amend or repeal the bylaws. Now, since the stockholders can delegate the power to amend or repeal the bylaws by a vote of 2/3, the same voting requirement is imposed when the stockholders decide to revoke the power so delegated to the board with respect to the amendment of the bylaws. This ends my presentation on the Title 5 bylaws. See you again next episode.